Hi, good evening, everyone. Thank you again for coming. My name is Marina Sorochinski. I'm a professor at John Jay University, and I'm just helping coordinate this event. I'd like to first of all start by thanking the Jeffrey Desmond Foundation for sponsoring this event, for providing us with a great food that you hopefully had the chance to enjoy. I'd like to also thank the Pace School of Law for hosting us here. And once again, thank you for coming. So before we start with the panelists, I just wanted to quickly tell you a little bit about what this event is about, right? So today is October 2nd, and since 2014, this has been recognized as the Wrongful Conviction Day, and which was established by Innocence Canada, so we thank them for that. It's a day to recognize, to inform the public, to raise awareness, and to really highlight and give the voice to the people who have been failed by the justice system, who have been struggling with the system, or spent many, many years wrongfully imprisoned, and we'd like to really acknowledge them and also inform the community and maybe think about what we can do really to help. And so hopefully today we're also going to talk about some active solutions, not just about how bad everything is, right? So before our panelists start to talk, we'd like to take a moment to once again recognize those people who are in the midst of this struggle for justice or have been through it quite recently. And so Jeffrey Desmond, who is the founder of the Jeffrey Desmond Foundation, whom I will introduce in more detail later on, he will lead on this part.
Thank you very much. I want to thank Dr. Sorochinski, more affectionately known as Marina, for helping to coordinate this event. It's quite extraordinary to have a professor of a different educational institution who will take time and effort out to coordinate our event at a school other than where they teach at. So I definitely want to thank you for that. Let's all just give her a quick hand for doing that. So wrongful conviction, unfortunately, is not a rare thing. There's more than 2,000 people who've been exonerated nationally per the National Registry of Exonerations. And so in keeping with that spirit, I want to start out by acknowledging people who've been through and survived wrongful convictions themselves. And the first person I'd like to call up here to speak with us for a few short moments is recently exonerated Anthony DePippo.
Today is International Wrongful Conviction Day for 2017. And a lot of our comrades, our fallen comrades, are still behind bars. Some of those people are John Juca, Major Tillery, Ronnie Long, John Adrian Velasquez, JJ, and there's numerous people. And me, myself, I was locked up for 20 years for a crime I didn't commit. I was tried 3 times, rape and murder of a 12-year-old girl. Not just a basic crime. I I was falsely accused of robbing somebody or killing a rival drug member. I was falsely accused of the most horrific act you could be in prison for. And during those 20 years, I never gave up hope. Through perseverance, through people who believed in me, like Jeffrey Bastuk, like Mark Baker, Mark Ignifulo, and the great people in this world that believe in the actually innocent. I'm here as a free man. And I would like to give great thanks, and I kind of get teared up when I think about these things. It's to all the freedom fighters who stand behind people, and for all of you that want to have a career in law, I urge you to at least one time in your life, take a case pro bono. Just take a case, just one guy, and we'll make the world a better place. And with that, I would like to say thank you. Anybody wants to know about me, I'm on the internet. It's Jason Monroe for conviction. God bless you.
So the next person I want to acknowledge has been home for 5 weeks. He was away for 22 years. I want to say more, but I want him to tell his own story. He was a Jeffrey Bastuk Foundation for Justice client. It was a total collaborative effort in securing his freedom, along with the Pennsylvania Innocence Project, Attorney Michael Wiseman, Decarcerate Pennsylvania was involved, Lonnie was involved, many people were involved. We were just involved on a public relational level. It takes a village to wrongfully convict people. It takes many people fighting on multiple levels in order to help people secure their freedom. So I want to welcome and ask to come up and share some words with us, Lorenzo Johnson.
Prosecution misconduct. I was failed twice by the judicial system. I did a combined 21.5 years in prison. I did 16.5 years in prison, and my case was overturned on the grounds of insufficient evidence, which is a legal exoneration, basically, because the bars are retrial. And prosecution had one appeal left. And the appeal got to the United States Supreme Court, and I was released. Let me bring you back first. On October 4th, 2011, my case was reversed. I was serving a natural life sentence for a crime I didn't commit. And on January 18th, I was released by the Third Circuit Court of Appeals in Philadelphia. I came home for a mere 148 days when I got a phone call from my lawyer saying that I couldn't really understand what was crying on the phone. All I heard was the Pennsylvania Superior, or the Supreme Court, not Pennsylvania, United States Supreme Court reinstated the conviction. So, that's every exoneration worst nightmare. That's you go numb when you hear something like that, but you got to go back. So, to make a long story short, the United States Supreme Court reinstated my conviction without allowing my attorneys to file briefs or oral argue opposition, which is common procedures. So, after 140 days of freedom, after 6.5 years, I had to go back. So me and Jeff took that ride back to Pennsylvania. I'm from Yonkers. Me and Jeff took the ride back to Pennsylvania to turn myself in to fight again. So it took 5 more years for me to get my freedom back. But within the 5 years, we got evidence from the prosecution that they knew I was innocent from day one. The only witness they had in the case was originally labeled a suspect. We never knew this because they never turned the paperwork over to us. And they never gave us a statement from the only witness, and we honored a police summary of what this witness said. But once we got a hold of this witness statement 18.5 years later, it exonerates me. It shows that I was innocent and that this couldn't happen the way they said it happened. So I stand before you now as a free man, and it's my job to fight. Like my co-defendant, he's still sitting in prison, 22 years innocent. And he's waiting for the appeal process to help him. But I stand for a lot of other people that's innocent. All the innocent people that's in prison, I stand for them. And these are my comrades around me that's doing the same, and I appreciate everybody to come out. And as far as the law students, please, when you do get your before I take it. Please look at the entire discovery. Don't let a discovery start on page 9 or 20 or any page missing. Please get furnished with everything. And once again, I thank everybody for coming out. Thanks.
Yeah, so Wrongful Conviction Day is not only for the people who survived and made it out, but it's also very much about the people who are still fighting, who still wanting to come out. We heard Anthony DePippo share some names with us, and I want to share some pictures of some people in what's cases that are kind of like universally recognized as innocence cases, and cases that I do believe that will ultimately end in exoneration. So let me share a few of the slides here. So there's a noted professor at Elizabeth Hobbs School of Law here at Pace University, who's one of the country's experts on prosecutorial misconduct, and I won't say anything. I'll kind of nudge my head. I think we all know who we're talking about. And so there's a really interesting paragraph that I snipped out from a Huffington Post article regarding this first person I'm referring to. And so his quote, Nicolazzi, a tough Brooklyn homicide prosecutor and a star of TV's investigative discovery channel, claims that the right to privacy of a mentally and emotionally disturbed felon, a fugitive who had absconded from a drug program and had committed over a half dozen other drug violations, outweighed the right of a young man charged with murder to a fair trial, and outweighed her duty to disclose to the defense any information that would have aided the defense in attacking the credibility of her key witness. So if you didn't want to read the full article, the link is below there. John Juga did not receive a fair trial. That's John Juga. He's waiting for a decision from the appellate division right now. I believe he has 14 years at this point. John Adrian Velasquez has in close to 18 years at this point, so the highlights of his case, or lowlights, however you want to phrase it, several witnesses have recanted who originally testified against him. An alternative suspect whose name appears in the original police reports was actually identified and confessed to several civilian witnesses, confessing to the murder, and yet he still remains in prison. His bid at overturning his wrongful conviction case are rejected by the Manhattan DA's office, and thus far the courts have refused to simply allow him to present his new evidence to the court. Just allow the witnesses to come in and testify, and have the judge hear them and evaluate their credibility, have them be subjected to cross-examination. Even that, to this point, is too much. So the struggle continues. Lastly, we have Andrew Krivak. So Anthony DePippo is free. He's with us tonight. Anthony had a co-defendant, Andrew Krivak, who remains in prison, basically on the exact same set of facts that Anthony is acquitted and is listed on the National Registry of Exonerations. The only difference in Andrew's case is that in his case, the same polygrapher who coerced a false confession out of me did the same thing to Andrew. And other than that, the case is exactly the same. All of the evidence of an alternative suspect, a serial rapist, which is what Anthony got his last reversal on, which is the evidence which, when finally he was allowed to present to the jury, they acquitted him, unlike the two prior times when he was wrongfully convicted. Andrew's argument, of course, is that he should have the same right to present the same evidence. And the legal standard, of course, is whether that new evidence probably would have resulted in a different verdict. And here, because of the unique circumstances. I mean, we kind of have the answer right here in front of us as to whether that would. So Andrew is a Despotic Foundation client. His post-conviction motion was turned down when he argued for the new trial based on that new evidence. And then also the second ground was that he argued that he should have the right to present the evidence as to the polygraphist who I won a civil court judgment against. That should also be another piece of evidence that he should be allowed to present to the jury. The judge, in a rather ridiculous motion, rather ridiculous decision, turned down the motion. He went back to a 1981 treatise which referenced the reliability of confessions, saying that all this evidence as to the serial rapist would not have made a difference in light of the confession. So recently he was granted leave to appeal that decision to the appellate division. He was interviewed on the Wrongful Conviction blog by Jason Flom. The link to it, you can check the link out and listen to a rare prison interview. So those are the people that are struggling to get back home. And, you know, there's an urgency. You know, there's an urgency for people who are wrongfully in prison to be released as soon as possible. You know, the clock doesn't stop. You don't get to relive the days that you missed once you are free. And so with that, the last part of this portion of the program, which is going to be the most difficult, but you know, it's really necessary. One of my goals is the first exoneree for my foundation. You know, we love to keep his memory alive. I would like to ask Alice Lopez to just simply come up for a brief moment and just stand next to me. You don't have to talk, huh? Can you come up for a second? Because it's important to put a human face. You know, this is what we're talking about. Look at the screen. Alice's husband, our first exoneree, he was in for 23.5 years. He was exonerated, and he lived for 1.5 years after that. So these are real cases, real consequences. You know, it's very important. Do your job ethically. If you're a prosecutor, go all out for your clients. If you're a defense lawyer, and really do think about taking on at least one pro bono case on behalf of someone wrongfully convicted. There's nowhere near enough people doing this type of work. It's an urgency to get people out as quickly as you possibly can. So there's not more results like that. So thanks, Alice, for being brave, for coming up here and joining us tonight. Thank you very much.
As I mentioned, the Wrongful Conviction Day is about recognizing those who are struggling for justice. And it is often missed that the families are in that struggle. Their loved ones, the families, everybody related to the person behind bars is also in that struggle, right? So we have to hear them and recognize them and acknowledge their struggle just as well. So thank you. Thank you for being here. All right, so today we're talking about prosecutorial misconduct and its role in wrongful convictions. This is what prosecutorial misconduct was defined as back in 1935 in Case Berger. The United States, it said that prosecutorial misconduct means overstepping the bounds of the propriety and fairness which should characterize the conduct of such an officer in the prosecution of a criminal offense. Right? Wrongdoing. A mistake could be as well, right? Problem is that these, the misconduct, these mistakes, are a major case for wrongful convictions, right? 36 to 42% of known wrongful convictions contain some form of prosecutorial misconduct. So it's a major issue, and that is why we are talking about it today, and hopefully also informing you of some of the solutions that are possible in this case. So our first speaker is Professor Ben Gershman, who is a former prosecutor former prosecutor with the Manhattan District Attorney Office. He's the author of many books and articles on prosecutorial and judicial ethics, and he served for 4 years with the Special State Prosecutor investigating corruption in the judicial system. He's one of the nation's leading experts on the prosecutorial misconduct, and is active on several bar association committees, frequent pro bono litigator, and a member of the It Can Happen to You coalition. The leader is also here today with us, and we'll speak later. So Professor Gershman, a law professor here at Pace.
I feel very to be here. I just want to say how honored I am to be among people such as Ian Katabi and Enzo Johnson and Pippo, Alice Lopez. You know, there was a time when our society wouldn't even accept the fact that innocent people are wrongfully convicted. When I was a prosecutor, I'll make you bet, if you ask any prosecutor anywhere, have you ever prosecuted or convicted an innocent person? I'll make you bet every prosecutor would say no. It doesn't happen. Prosecutors don't convict innocent people. One of our great legendary judges, some of you may take courses. I see a bunch of my students here, and I'm just happy you're here. And as I say, we just happen to be on a panel. They've got two legends of their own, Jeff Bastuk and Bill Bastuk, who's founded the chief. And I just feel that this never would have happened. You know, had we not seen the revolution in DNA evidence. This judge, his name was Learned Hand, and I'm sure you've heard of Learned Hand. And here's what Learned Hand, the great 10th Supreme Court Justice of people, he said this in a case called the United States against Garson in 1923. Quote, our procedure has been always haunted by the ghost of an innocent man convicted. It's an unreal dream. That's what he said. And as I say, you'd ask any prosecutor, and every prosecutor would have said, no, innocent people don't get convicted. You don't try innocent people. I don't know. I was a prosecutor for 10 years. I prosecuted a lot of people. I remember one case which stands out. Let me just throw it out to you because it stands out in my mind. I was in the trial bureau. I was prosecuting rapes and robberies and some murder cases. And this case came on my desk. It was a robbery of an elderly man in a vestibule in some apartment building in Upper Manhattan. And it just seemed like an ordinary case. The lawyer, and sometimes you talk to these lawyers, and sometimes you trust some lawyers. Not all lawyers, but sometimes you trust lawyers. You try to stop the relationship. And this lawyer said, then check this one out. My client is innocent. I'm not positive. How do you know? I just know. I looked at the case. It was a robbery, knife point. When evidence taken. There was no corroboration, so you're relying on the testimony of the victim. I went to the area where it happened. The vestibule was fairly well lit, not great. The lawyer said, listen, can you take a lie detector test? I said, okay. We gave him a lie detector test and he passed. And our polygraph expert, I trusted. I said, what's his alibi? He doesn't have an alibi. Which to me was almost a confirmation that maybe he was innocent, because people might have an alibi, but that alibi might be contrived. The fact that, how do you remember where you were 12 months ago at 2 o'clock in the afternoon? So the fact that he was locked up by the housing police a number of times, young man, and I had a bad feeling in my stomach. I had him come into my office before the trial, day before the trial. I had the detective give me about 20 photographs of similar-looking people. And I spread the photographs on my desk. I walked out of my office. I said, sir, look at these photographs carefully and select the person that attacked you, assaulted you. And he picked out the wrong picture. He didn't pick out the defendant. I told him, do it again. And he picked out the wrong person again. I told him, sir, I can't prosecute this case. My bureau chief wasn't too happy. This was at a time when the idea of innocence doesn't really figure that much. I made a motion to the judge. I remember vividly the judge looking at me with a lot of amaze. He wasn't happy with this, but he dismissed the case. And I guess at this time, how many times does a prosecutor ask to have a case dismissed? Today it seems like innocence cases recur almost every day or every other day. There was a big newspaper article about it, and people in my office looked at me as if I was crazy. Whatever it is. And as I say, we probably wouldn't be talking about innocence today and about prosecutorial misconduct, had it not been for DNA evidence. Because with the advent of DNA evidence and innocence projects after that, we know from DNA evidence that eyewitnesses make mistakes. Right away we know that for certain. And that's like the breakthrough. Because once we know that mistakes in the system happen, and they happen sometimes without any misconduct, they happen because of the systemic problems that we have. For example, eyewitnesses. We know today much more than we knew 20 or 30 or 50 years ago. We know that eyewitnesses often are unreliable. And my concern always has been a prosecutor has to look very skeptically at an eyewitness. You can't just take the eyewitness's word, because we're not talking about an eyewitness lying. We're talking about an eyewitness who is making a mistake. And so prosecutors have to struggle with cases. I don't think prosecutors struggle enough. I think prosecutors accept the proof. They're oftentimes younger people, and the cops are very, very seasoned and savvy, and sometimes the police will encourage or prosecutors to move ahead of the case. Prosecutors know that they have an easy way out. They know the easy way out is to negotiate a plea with the defense attorney. Now that's the easy way out. That's the kind of fail-safe. So you don't have to worry about innocence. Although today we know for sure that thousands of defendants, among the hundreds of thousands of defendants who plead guilty, we know that thousands of defendants who plead guilty probably are innocent. But they view the risk of going to trial as much greater than the risk of taking a plea and getting a sentence that's substantially less. And prosecutors know that too. And they know that they're in control. But I hope people here understand that when you think of the criminal justice system, you've got to believe that the prosecutor is the most powerful official in the system. In fact, a prosecutor is the most powerful official in our society. I mean, the prosecutor has the power over people's reputations, people's liberty, decisions. Prosecutors make all those decisions. Those are discretionary decisions that only the prosecutor makes. You know, if you look at the National Registry of Exonerations, it started in 1979. It's a list of all the defendants, all the persons who've been exonerated. And again, I believe that the persons who have been officially exonerated, I think it's now over 2,100. But this is a tip of the iceberg. Most of these exonerations are from DNA evidence. I believe that 75 or 80% of them are DNA evidence exonerations. It's very difficult to get an exoneration when there isn't DNA evidence that almost conclusively proves that somebody else did it. But if you look at the National Registry of Exonerations, and they list the categories that are attributable to the wrongful conviction, you'll see that probably well over a third, maybe over 40% of it, are attributable to prosecutorial misconduct. Some are attributable to false confession, as the tragic case of Jeffrey Bastuk. Some are witnesses who lied, police misconduct. But you know, the prosecutor's role is such that the prosecutor runs the show. Just understand that. The prosecutor has all the evidence. The defendant doesn't have any evidence. All the evidence that's accumulated is given to the prosecutor, and the prosecutor then decides how to use that evidence. I will say that sometimes police don't give the prosecutor all the evidence, okay, and that may be a problem. But you see, the prosecutor should say to the police officer, I want all the evidence. I will hide something. I want you to give me everything you have. But the prosecutor has to be in charge of the case. I mean, too many prosecutors defer to the police. I mean, some of you may know about the case in Brooklyn. The cases in Brooklyn involving Detective Scarcella. That's a great name. I love that, Scarcella. Where he took over 50 confessions from suspects. It was amazing. All of those confessions seemed like they were exactly the same. And all those confessions had different witnesses. You know, I mean, in looking at those confessions, if I was a prosecutor, and I start getting some of these confessions from Scarcella, I have to think that really, there's something wrong. Ask questions. Don't just take it. But, you know, that's the problem with some prosecutors. They don't ask questions. They don't struggle. It's easier to just use your file, see the evidence is there, and just move ahead with the prosecution. And some of the prosecutors say, look, I'm not playing God, I'll let the jury decide. But you know what happens if you do that. If the prosecutor isn't a gatekeeper, if the prosecutor doesn't look closely at the evidence and say, maybe this evidence is weak, maybe this evidence is not all that credible, maybe the eyewitness is not reliable, the prosecutor's got to say that because you know for certainty that even if I'm a prosecutor and I think that eyewitness may not be correct. I think there are reasons to doubt that, especially when you don't have corroboration. You know damn well that that prosecutor gets into court and the prosecutor says to the witness, I want you to look around the courtroom, sir, and see if you see in this courtroom the person who robbed you and stuck a knife into your throat. Do you see that person in this courtroom? And the witness looks. Now, who's he going to look at? The jury. And it's very dramatic. You know? And then that's the person. That's the man who I'll never forget that person's face for the rest of my life. You think that has an impact on the jury? You know, you got to. I mean, there are just so many cases, so many cases. I don't know if any of you have seen the documentary called The Thin Blue Line. Have you ever heard about it? If you haven't seen it, maybe you should. The documentary made by Earl Morris, I think it was in the late 1980s, at a time when we really didn't think too much about wrongful convictions. I was in the field. I saw that documentary. I looked out. I was stuck. That was good. I immediately wrote to Randy Bale Adams. I want to help you. He wrote back, indicated he was eventually exonerated because I filmed in large parts, and it was shown that the prosecutor prosecutor in the exculpatory evidence. The prosecutor, the key witness, who was absolutely a liar, and you have to know from looking at that film, because there's an interview with this witness, and you look at it, you say, how could a jury ever believe this person? If you point the finger, right? The jury can figure it out and say, yeah, change it. After litigation, the prosecutor, the defense, after the defense learned about this witness, and all of the exculpatory evidence that the prosecutor's hiding, they wanted this witness back in court. And the prosecutor said she's left jurisdiction. I don't know where she is. It's not true. He knew where she was. The prosecutor, case was reversed. And this prosecutor, oh, Donald. But anyway, the Dallas DA's office with this prosecutor were, they had 7. Anybody, any prosecutor can convict a guilty man. It takes a great prosecutor to convict this. And so, you know, you run misconduct. I mean, you look at the cases of Hurricane Carter, prosecutor with evidence that resulted in his living in a little cell. Building storm, hurricane. Michael Morton in Texas, the prosecutor had a bag full of evidence that was conclusively proved that Morton was innocent of killing his wife, but the prosecutor didn't give that to the judge. So the prosecutor in that case, Ken Anderson, he was disbarred. The prosecutor in the Cross case, Michael Nifon, he knew that the victim wasn't victimized by these people across cities. He knew that because she had sex with a bunch of other people that weekend, and he knew she was wrong. He knew it from everything about her testimony, about the case, and he never disclosed anything. He never disclosed anything. Ultimately, these kids were exonerated, and Nifon was disbarred. Sometimes these things happen, but most times prosecutors don't get punished. The prosecutors who prosecuted the late Senator Testy, they failed to disclose a huge amount of evidence that would have shown these idiots likely didn't do what he was charged with. And these were the senior prosecutors in the Justice Department, the public defenders. Wow. And they did, and you know, it turned out the judge threw the case out, the Department of Justice decided to see the dismissal of the case. And the prosecutors were most responsible, they were able to punish the guy. 10 days or 15 days salary cut. That was their punishment. And usually the prosecutors are punished. What do we do? What do the prosecutors do? Yes. The Central Park jogger case. I mean, sometimes you see that forensic evidence is so misused. In the Central Park jogger case, there was a piece of hair that was, the prosecutor said, there's a match. The hair matches the defendants. Now, you know, hair is one of the worst kinds of things, but the fact that it's a match, it was a match as much as my hair matches 12 people in this room or something like that. You know, it doesn't mean that much. And yet the prosecutor was selling this to the jury. There's a match, and nobody stopped the prosecutor. And we know they were innocent, the confessions were false and all that. And then, you know, case of Lloyd Brown, that got 15 or 20 years in jail in New York. The key evidence was bite mark. And the bite mark showed that the person had at least 16 in that mark. But Lloyd Brown, the defendant, only had 14. The prosecutor's expert, the odontologist, said Brown didn't do it. So what does the prosecutor do? He says, I want you to write it down. I don't want you to talk to the defense, and I'm not going to call you a witness. The prosecutor got another odontologist to say, well, Brown could have done it because in the struggle, maybe it looked like 16th when it really was. Brown was exonerated, you know, like a tribunal. And let me just finish with this case, because this is the case that continues to really affect me. It's a case of Jonathan Flynn. And you probably know that he's exonerated. He spent 25 years in jail. But, you know, I believe that misconduct means an effect. There is a kind of a willfulness or a kind of deliberateness. I don't really want to say that mistakes, because people make mistakes, you know. doctors make mistakes, they chop off the wrong leg, or umpires make mistakes, and these can play. I don't know, law professors can make mistakes. But I don't think prosecutors really make mistakes. I think they know what they're doing. And so I see this kind of as the livers on me. But the case of Jonathan Fleming, I think that so much, if you want to call it prosecutor irresponsibility, unprofessional conduct, so much is bad, terrible, terrible judgment, in not looking at the case carefully, in not being skeptical. I mean, Jonathan Fleming was charged with the murder of one people in Brooklyn. The only evidence was from an alleged eyewitness from an apartment house 400 feet away, at night, dark, identifies Fleming as the shooter. This woman, it turns out, made a deal with the police, and to get her case dismissed, she turns into a murder. There's no corroboration. And in fact, after Fleming was convicted, she recants. But the judge didn't believe her recantation, the prosecutor didn't believe her. The recantations don't measure up in our system. Anyway, this was Jonathan Fleming's alibi. He said, I couldn't have done it because I was in Disney World with my family at the time of shooting. And I remember I made a phone call from Disney, from Orlando, to somebody in the United States, and he received a phone call. He gave to the Orlando police. And they had it. And they also interrogated staff in the hotel where he was demonstrating. And he was there. And so the Orlando police sent the Brooklyn police the receipt, phone receipt, and the report of the Fleming was there from the report. The police, apparently, according to the prosecutor, never gave it. So the prosecutor claims he didn't know about it. First of all, what do you think that the prosecutor hearing his alibi and having the family of Fleming say, I was in Orlando, wouldn't the prosecutor want to really push that and find out, and how does the prosecutor know? And I'm assuming the prosecutor may not have been involved. But the prosecutor, after the Fleming's family testified, the prosecutor goes up and sums up to the jury and says, you could have killed this guy anyway. You could have seen that Orlando. Flown back. What prosecutor is that? I guess I feel really right now, as I read these cases, I see that some prosecutors' offices are now instituting conviction reviews. The prosecutor, Ken Thompson, how many years there, and a conviction review, it's a good idea, even though it's in the prosecutor's office, and even though the person's bad, they still take a second look. A second look at your right is a good idea. Maybe a couple of dozen DA's offices around the country have activities, and more will start doing more. And I wrote an article years ago about the lead prosecutors where I talked about how the accretion of power and how the courts are giving prosecutors so much more latitude, and how professional discipline is totally zero when it comes to the prosecutor. And that's really the last 25 years. The prosecutor's power has increased. But somebody said to me, right now I have what called a new prosecutor, because some prosecutors are changing. There are some prosecutors that are really there that really are trying to reform the system, try to look closely at their cases, try to respond. Maybe that's what we can vote for, because I don't know that professional discipline matters. I don't think many prosecutors really will reform themselves now. But some, the question of your own personal integrity and your own sense of professionalism and your own sense of seeking to serve the courts of justice. More prosecutors think like that. Maybe this is the candidate reform itself. I really don't know. But I'm an optimist. Even though I write about it a lot and investigate sometimes the prosecuting system and so on. I see people that are very Bastuk and Jeff yesterday, and to me they inspire me.
youth, whose mission is to provide reform, educate, and mobilize citizens, serve as a source of support for those who are wrongly accused, and increase the public awareness of the many forms of prosecutorial misconduct. Bill was also a former Monroe County Legislator, who also previously served as a staffer for a New York State Senator, started the coalition after his own acquittal in 1 hour for a rape that he did not commit. And the prosecutorial misconduct in his case, including repeated withholding of critical diary entries that by law were supposed to be turned over, went unpunished. So, Bill, please.
Thank you very much. And Bennett is always a tough act to follow, so, you know, but he certainly gets your blood moving. And Jeffrey, I've come to know as a very dear friend. Since formation of it could happen to you. As a matter of fact, Jeff was one of the first exonerees that I ever met and spoke with. And now I'm staying at his house on a monthly basis. It's not like Hotel Heinz, though. Jeff is much more gentle. He doesn't interrogate me. Although, I must say, I don't think Jeff can quite escape being behind bars and some of what he tried to do. Because when I entered the bedroom today that I stay in the closet there was a ladder. And I don't know what the ladder was for, but I can only Jeff was having some...
I think you have an idea just by the fact of you mentioning that. So you guys can laugh. We do dark humor because look, this is serious things. We're fighting the good fight, so we gotta laugh so we don't cry. So it's all right to hit him with a little applause on that. Okay, humor's good.
You know, Bennett made reference to the wrongful conviction unit in Brooklyn. In the last 3 years, that wrongful conviction unit, just in 3 years, has asked a judge to overturn convictions 23 times. Now, you might ask yourself, what spurred this? Well, Charlie Hines, who was the prosecutor, do you know what Charlie's dream in life was? He wanted to become a U.S. Senator. He ran a primary for the U.S. Senate in the 1980s. He was talking about running again. He considered running for mayor of New York. The Brooklyn District Attorney's Office was his path to higher office. So here in New York, we have a culture, and across the country, and not every DA's office is a bad office or a corrupt office, but it only takes one prosecutor in one office to have that culture of being the prosecutor in one of the most cases. And I just want to refer you to, and I imagine there's some law students here today. Vanity Fair this past summer had an article on a murder of a trapeze artist in Las Vegas. This occurred in the 1990s. But in this article, written by Megan Rose, who's a nationally known reporter, it notes, in legal circles, prosecutorial misconduct is viewed by many as a pervasive problem, an epidemic, as one prominent federal judge called it in 2013. Jurisdictions, large and small, are riddled with corrupt practices. Misconduct lies behind in more than half of all cases nationwide in which convicted defendants are ultimately exonerated, according to the National Registry of Exonerations. Driven by a win at all costs culture, such misbehavior is especially hard to root out because, as experts say, there is little incentive to play by the rules. Appellate courts often sweep misconduct aside as harmless. Top prosecutors, burnishing their own careers, rarely punish underlings for it, and indeed, they often flourish, going on to become judges, reluctant to police their former peers. And the law gives prosecutors broad immunity from civil lawsuits, even when their bad behavior lands the wrong people in prison. In my case, it cost me a second mortgage and $150,000 that I'll never see a penny back. So, the other thing about the Las Vegas prosecutor here, in this particular case, he had an incentive system. When you walked into the Las Vegas prosecutor's office in the 1990s, early 2000s, there was a big clipboard. And on that clipboard were stars for the prosecutors that got the most convictions. So what happened was, whenever another prosecutor walked in and didn't see his name up there, he knew he better damn well find somebody to prosecute and convict. Another article this past summer, and this is great because the media is picking up on what's taking place in our prosecutors' offices. This was a Time magazine article that appeared on August 6th in New York Times Magazine. This was a case in Memphis in which a daughter was convicted of murdering, wrongfully convicted of murdering her mother. And in this case, the prosecutor had in place a tradition in Shelby County called the Hammer Award, a commendation with a picture of a hammer, which supervisors or section chiefs typically take on the office door of all prosecutors who won big convictions. The Hammer Award. Now, this article goes on to say, and it talks about Brady, the catch-22 of Brady is that you have to find out they're hiding something to have a claim. The honor system, and think this, the honor system created by Brady is remarkably different from the process for disclosing evidence in civil cases, in which both sides are entitled to review relevant documents and depose each other's witnesses. If the civil plaintiff, who seeks primarily the payment of money, must share his evidence in advance of trial, wrote Merriman Bear, a Brooklyn Law School professor and former assistant U.S. attorney, and a 25 article in the Columbia Law Journal, then surely the prosecutor who seeks the defendant's loss of liberty or life ought to suffer the same obligations. Common sense? So what do we do about this? What do we do about these 23 prosecutors? Where do people go? Where does the defense community go? To complain about a prosecutor who repeatedly is a serial violator in opening and closing statements or in withholding evidence. Where do we go? There's no place to go. The prosecutor, as Bennett pointed out, the most powerful person in the criminal justice system, and in many communities, the most powerful political leader, is not subject to one sliver or ounce of accountability. Every other profession, I don't know what all your professions are out there, but I'm sure whether you're a laborer or a school teacher or a doctor or a real estate agent or a banker, you will face some punitive measure if you violate the code of conduct and standard. When we put somebody away for 15, 10, 20, 30 years, all we do is pay out millions of dollars in wrongful conviction settlements. Very often, while the true murderer rapist is out on the street committing another rape, murder, felony, burglary, arson. So It Could Happen to You began a campaign for both disclosure reform and to establish accountability for prosecutors. And what happened was, in 2014, we were meeting with Senator John D. Francisco, upstate New York conservative Republican. And the senator's like, you can have all the reform in the world, but unless there's some oversight and sanctions for prosecutors, they're going to continue to get away with it. If you mandate automatic discovery, you can think that since they're withholding it for 45 days, they're going to automatically turn it over. The senator said, you have a suggestion. And we came up with a suggestion. We said, why don't you establish a commission modeled after the Commission on Judicial Conduct, which has been in place for 40 years. 40 years ago, the judges were kicking and screaming and saying this was going to create a crisis of confidence in the justice system and have a chilling effect. Some of the same arguments you're hearing from DAs now. And then that same year, 2014, we were making a presentation to the Black, Hispanic, Asian, and Puerto Rican caucus in the legislature. And Senator Nick Perry, downstate liberal Democrat, said, wait a minute, this commission makes common sense. I represent some areas in Brooklyn in which people have a lot of complaints about prosecutors, but they don't work well. So now we have a bill in the state legislature that is co-sponsored by one of the most conservative Republican senators from upstate New York and one of the most liberal Democratic senators from Brooklyn, New York. That tells you something. That people get it when it comes to freedom, regardless of where you stand politically. So this bill, to establish the Commission on Prosecutorial Conduct, okay, is moving, and it's got legs. In 2015, the bill was moved into Senate Finance and into Assembly Ways and Means. Now, bear in mind, Senate Finance and Assembly Ways and Means are purgatory. That's where bills get their final blessing before going to what's known as the Rules Committee. Now, the Rules Committee is often termed hell, because that's where bills live or die. On the Rules Committee is basically the brethren leadership in the Senate and the Assembly. View it as the cardinals in the Vatican. And they make the decision as to whether or not this bill comes to the floor for a vote. Now, this bill has sailed through judiciary, through all the subject committees, and it's picked up a lot of steam. In 2015, the bill had 27 co-sponsors in the Assembly. In 2016, it had 40 co-sponsors in the Assembly. This past session, we have 65 co-sponsors. We have, in the Senate, a number of ranking senators that support the bill. We also have what we call chickens. These are the senators who can't make up their minds. They tell you one thing, and the DA picks up the telephone and says, you know, I need the ticket next year, and I might not endorse you. So these law and order landlords, okay, control votes. I want to tell you, in 2016, we had the votes. We only had 4 responses. We had the votes in the Assembly. Up until the last day, Jeffrey Deskler was there with me, off the floor of the Assembly. We were counting the votes. This was the second to the last day of session. I get a call from Assemblyman Nick Perry. Bill, we got to pull the bill from the floor. It was on the Assembly calendar. What do you think happened? The DAs zeroed in on the Westchester County and Queens delegations. And that morning of the final day of session, Queens Assembly members had gone home sick. We called it the DA's flu. I swear, this happened. They were nowhere to be found. They got their important votes in and they disappeared. One Assembly member, who was a co-sponsor of the bill, received a phone call from his son, who worked at the Queens prosecutor's office, saying, "Dad, come off this bill, please. You know, for the boss." Those are the types of shenanigans. There's another Assemblywoman, Sandra Galiff, and I'm not afraid to mention her name. She was a daughter who works in the Westchester DA's office. We got a phone call. Mom, please don't worry. My boss says it's not. We've overcome that. We've overcome these shenanigans that took place in 2016. Now, I just want you to know the arguments that the DAs are making to your state senators and your assembly people and what the myths are. Because this bill can pass if the governor gets behind it. Our goal in the next 3 months with this broad coalition with 14 memos of support that includes Labor, New York State United Teachers, Catholic Conference, New York State Association of Criminal Defense Lawyers, the wrongfully convicted, the wrongfully prosecuted. We've got broad support. Peekskill, NAACP. Everybody you talk to thinks this is common sense. There's nobody in the world that doesn't believe that prosecutors should be held accountable for their mistakes. So, what the prosecutors tell the legislators are that there's this grievance committee. These are appellate courts that you can file a complaint against the prosecutor. Well, we file for certain appellate divisions, we file requests for reports to see whether or not the grievance committees were investigating prosecutorial misconduct. We got the past 10 years reports out of New York City First District. We went through them, not one case. Now, this grievance committee does exist, but it's for lawyers in the private sector, civil lawyers, who, matrimonial lawyers, real estate lawyers, who, for example, steal from their clients. You know, they hold escrow accounts, Christmas time comes, the lawyer's not doing good, he wants to buy his wife a wing ring, so he dips into the escrow account and buys a Christmas present. And they get punished, and they should. So these grievance committees, in 2015, when this bill hit Senate Finance, they're right, when a bill hits a committee, like Finance, they don't put it on the agenda unless they know they got the votes to pass it. That's the way this system works now. So the DA's Association saw the bill on the calendar on the morning of June 5th, I think, or the 6th, 2015, and they were in Dunkin' Donuts in the Capitol in droves. Matter of fact, one key Republican counsel came up to me and said, "Shh, no." I said, "What's wrong, David?" "They're here to kill the bill." So they met with Senator DeFrancisco. that morning to try and keep the bill from passing Senate Finance. They did not succeed. But they pleaded, they were on their hands and knees, and the senator, they talked about this grievance committee. And they said, you know, we got a system. So the senator said, well, can you give me some examples of prosecutors who have been not necessarily punished, investigated? And the DA said, we'll be back to you in a couple of weeks. To this day, 3 years later, after repeated attempts, there has not been one case submitted to the senators. Quite to the contrary, and I'm going to close with this because this is Jeffrey Love's last statement.
Yeah, but mention, will you please share with everyone though, before you end though, please share the bill number, because we really do need everybody to call your elected officials. We need to push back. We need to let everyone know that we need this legislation passed.
So what I want, and I'm going to give you the bill number in 1 minute. So, in 2016, we issued a report that could happen to you, citing the 25 most recent cases of prosecutorial misconduct. And most of those cases were 2014 and 2015 cases, by the way. And the DAs asked the Assemblyman and the Senator to hold a hearing on the commission. So there was a joint hearing in the first week of June in 2016. And at that hearing, the DAs came in, and Bennett was asked to testify on behalf of the commission by the Senator. Bennett, as eloquent as he was, took it to the DAs. And the Queens District Attorney's Office was there. Now, Queens ranks almost as bad as there have been over 200 cases of prosecutorial misconduct in Queens over the past 20 years. So the Queens assistant prosecutor, the office manager, as they call him, was there. And he was asked by the state senators about this pattern that's emerging of prosecutors cheating in opening and closing statements. You know, going over the line, kind of making up things. And the Queen's prosecutor said, no, that's not really happening a lot anymore. In fact, this kind of not really happening that much anymore. And generally, you know, it's a young, new prosecutor that makes a mistake and we discipline him internally. But we don't want to ruin his career. 1 month later, in July, the appellate division reversed a double murder in Queens. This was a mother whose baby was killed as well as murdered. The judge cited in the reversal pervasive prosecutorial misconduct. In fact, when I showed the case to Bennett, who's read more misconduct cases than anybody in the world, he said he'd never seen anything like it. A judge being so outraged. This, by the way, was a seasoned 30-year prosecutor. This was no rookie. He knew exactly what he was doing. And when he was asked by the New York Law Journal about the court's decision, the reporter said, what do you think about this? He said he was shocked. Because this was one of his cleaner closing statements. Quote, there you have the culture of the prosecutor, of the arrogant prosecutor. Now that case, by the way, was taken by the New York State Association of Criminal Defense Lawyers. And they wrote, and they filed a grievance in that case. Now you would think, you know, this is like the Super Bowl of all cases. If they're not going to look at this case, what are they going to look at? Bennett felt right there with us. I went in December 2016. This past March, what do you think the grievance committee said? It's not really relevant. 1.5 page. 14 pages of documents, 14, 20 pages we submitted. They submitted a 1.5 page brief that was probably written by some new law clerk. Now, how do we stop this nonsense? Okay, the bill. Senate Bill 2412B, Assembly Bill 5285. And actually, it's 2412C now, because we had to amend it again. And Assembly Bill 5285A, which is now B, excuse me. So it's Senate Bill 2412C, Assembly Bill 5285B. You need to insist that your state senator and your assembly person demand that this bill come to the floor for vote and that they support this. Now, if they don't have a bit of moral blood in them, you can tell them that about a study that we did that it just hits the tip of the iceberg. We looked at 11 wrongful conviction cases across the state. Those wrongful conviction cases cost taxpayers $120 million alone. And that's the drop in the bucket. That's just 11 cases. Okay. And those 25 cases that we revealed of misconduct in May of 2016, well, there's now 10 more cases. So it's now 36 cases. So quite to the contrary of the prosecutors, it has not gone away. It has increased. There's a common sense argument that's carrying a lot of weight, and it's every other profession argument. You call up your senator, you call up your assemblyman, and ask them why prosecutors are not accountable. Why I have a job and I am accountable. That's the key talking point. And this money that's being spent, okay, can be devoted to other good purposes, as my good friend Anthony likes to point out. Kids need school books, okay? We're fighting an open crisis. We don't have enough probation officers. This money is being spent on wrongful conviction lawsuits and on retrials that take place, by the way. There might not be a wrongful conviction, but every time there's a misconduct case, either the case gets thrown out the window, which is a waste of the court's money, or they have to retry the case and hire the investigators all over. Go back to the whole process. You pay for it. The taxpayer pays for it. And the other key argument is we need a commission to ensure that the accused right to all the evidence that they're legally entitled to is enforced. We need to ensure that Brady is enforced. There's no other mechanism to enforce it. And we're going to be having a rally in January in the Capitol. We'll be getting the word out here to Pace, where Jefferson Law School is. And we're key in Chicago, the other one. But this has got to be taken seriously. This is very close. Generally takes 5 or 6 years to get a landmark piece of legislation like this passed. It took Jonathan Rodest of the New York State Defenders Association 20 years to get a new indigent funding program in place. It took Raise the Age 6 years. Okay. So these are big battles. And the ones that are won are the ones that the governors get behind. So even if you don't call your assemblyman, even if you don't call your senator, call the governor's office. Ask for Alfonso David. Alfonso David. Easy name to remember. That's the governor's chief counsel. He's the governor's screening system. Okay. So Alfonso keeps track of these things. And if we can get this in the budget, it'll be a done deal. The governor can make this happen, especially in an election. Anything else? Any questions?
We'll do questions at the end, though.
Thank you. All right, our next speaker, Mr. Jeffrey Bastuk, who is an internationally recognized expert on wrongful convictions and the founder of the Jeffrey Bastuk Foundation for Justice that has to date exonerated 2 people and is working to prevent wrongful convictions by pursuing policy changes and raising awareness in the community. He's a current law student, as you've already heard, here at Pace University, and he's pursuing his dream here to exonerate the wrongfully convicted people as an attorney now. Jeff himself was exonerated 10 years ago, exonerated by DNA after 16 years of wrongful imprisonment. So.
Thank you. So kind of surreal to be here tonight. You know, in the fall semester, as it were, of my second year here at law school. Where to start? So let me just start off by saying that this panel and the movement, this is about trying to prevent wrongful convictions. This is about preventing prosecutorial misconduct. This is about putting a system in place to restrain otherwise unscrupulous prosecutors. This is about a punishment, if that's what the facts call. And hopefully this is also about trying to re-usher in the era of the prosecutor as a minister of justice. It's the prosecutor's job to seek justice. That means convicting the guilty, utilizing evidence that's gathered in a constitutionally acceptable fashion through a trial in which there is no misconduct that takes place, while at the same time dismissing charges, either pre-trial or post-conviction, against people who are innocent. There's not enough of that going around. So I want everyone to understand that that's the spirit of what this is about. And so to the extent that, you know, the word reaches any of the prosecutors through any form or fashion, they should understand everything that's said tonight and the efforts that are being made in that spirit. So anyone who's an ethical prosecutor, we have no issue with you. Our issue was only as against those members of your profession that engage in misconduct that results in wrongful convictions and that results in deprivation of constitutional and state rights, that results in compromise of fair trials, which ultimately throws into question the reliability of guilty verdicts. So with that being said, let me share with you a little bit about the prosecutorial misconduct that happened in my case, and from there I will transition to some of my thoughts in terms of what remedies can we do, can we put in place, can we strive for, above and beyond just the commission. I'm a member of It Can Happen to You. I believe in the commission. The commission is not the entire picture, but the first piece. So in terms of my own case, as was mentioned earlier, I spent 16 years in prison in New York State, wrongfully imprisoned for a murder and rape which I did not commit. My case happened here in Westchester. I was arrested in Peekskill. The trial in which I was wrongfully convicted happened here in White Plains, a short 9.5 blocks away from here. I was 16 when I was arrested. I was 17 by the time I lost the trial, and I was incarcerated wrongfully from age 17 till 32, where I was exonerated through further DNA testing. My wrongful conviction happened despite a pre-trial DNA exclusion in which semen found in the victim didn't match me. That was known before trial. Ultimately, I was exonerated through further DNA testing via the DNA data bank, which not only reaffirmed my innocence, but also identified the actual perpetrator, whose DNA was only in the data bank because left free while I was doing time for his crime. He struck again. He killed the second victim 3.5 years later. So my charges were dismissed on actual innocence grounds, and he was ultimately arrested and convicted. One of the major causes of my wrongful conviction was prosecutorial misconduct. So that happened in a number of ways. So, firstly, the day before officially receiving the FBI report, which stated that the DNA didn't match me, the prosecutor rushed to the grand jury to indict me so as to not have to present the DNA. Then the prosecutor, former prosecutor George Bowman, so he had this tag team that he used to work with the former medical examiner here in Westchester, Dr. Lewis Rowe, who wound up suddenly retiring after I was exonerated and I commenced a lawsuit against him in which the county ultimately had to pay millions of dollars for the fraud he ultimately admitted to. So their pattern was that Dr. Rowe would frequently alter his findings after initially making them in order to help fit the prosecution theory, i.e. help the prosecutor get conviction. So in my case specifically, and you should know this contextually, and I'll get right back to my point. When the medical examiner does an autopsy, there's audio and written notes which are taken contemporaneously as findings are made, and that's supposed to be in order to, as a method of ensuring accuracy. So it was only 6 months after initially making his findings, and only after the DNA didn't match me, that suddenly, for the first time, this medical examiner claimed that he found medical evidence showing that the victim, who was a 15-year-old immigrant from Colombia, who had lived a really sheltered life, who never went outside unless she was accompanied by her older sister or her parents, that she was sexually active. Basically, in order to wrongfully convict me, the prosecutor was willing to have this finding fabricated that basically said that the victim, who already had lost her life, that she was sleeping around. So it really didn't matter that the semen didn't come from Bastuk. That didn't mean he was innocent. That just meant that she slept with yet another person that close enough to the murder and rape. We found out later through the discovery process of the civil rights lawsuit that this medical examiner altered his findings in 3 other cases in Westchester, where the cases were prosecuted, not coincidentally, by the same prosecutor, George Bowman. He had been complained of in neighboring counties by law enforcement because he was moonlighting as a defense expert, where he was assisting people to get away with crimes in neighboring counties. So basically, whichever way the money flowed was the way that he testified. So the prosecutor knew that he had been complained of in neighboring counties, and none of that information was ever turned over to me. But the prosecutorial misconduct continued on the post-conviction level. So my imprisonment of 16 years didn't have to last that long, though. but there was additional misconduct that kept the ball rolling. Maybe from a technical point of view, you might not consider it to technically be misconduct, but when you have lawyers with law degrees who are familiar with forensics and they're making arguments to the appellate court that there's overwhelming evidence of guilt, even though there's a DNA test that excludes me, and that the fact that there is a DNA test that excludes that's no insulation to a conviction, and overwhelming evidence of guilt in spite of the fact that there is DNA, and making arguments, well, no, just don't Court of Appeal, don't agree to hear his case. There's no merit in doing that. And I remember when I lost in federal court because the court clerk gave my lawyer the wrong information regarding the filing procedures, and as a result of that, my petition for a writ of habeas corpus was arrived 4 days late, and Janine Pirro's office, who was the district attorney of Westchester, who took office after I was convicted, but before the first appeal, so she kept the ball rolling as much as she would like to distance herself from my case. Her office urged the court to simply rule that I was late, to not even get into the merits of my case. Even though one of my arguments was that I was innocent and I had the DNA to support my contention. And there was 2 different occasions where I was trying to get further DNA testing, and her office blocked me, several occasions from doing that. So changing gears, can someone just pass me the water, something kind of dry here. Excuse me. So I know firsthand, I know firsthand, I've lived firsthand, I've experienced firsthand the impact of prosecutorial misconduct, and then through my foundation, really long amounts of time it takes to get people out, and when innocence is clear, and there's meritorious arguments, and prosecutors, it's one thing if it's a gray area and there's room to disagree. It's something else when it's just so obvious from the new evidence or the pre-existing record, and these lack of good faith arguments fighting against innocence are made. I mean, it's just, and then to use technical objections, going against substantive arguments, that also has the impact of keeping injustices going. So in terms of various reforms, obviously, as I mentioned before, the commission is definitely a really big part of that. But above and beyond the commission, some other thoughts. There is a doctrine known as prosecutorial immunity, which states that no matter how egregious the misconduct happens, if it happens after an arrest takes place, then the prosecutor is deemed to have committed the misconduct as an advocate, and therefore they have immunity. So therefore you could not bring a lawsuit against them. So in my case, for example, so I was able through litigation to hold every party accountable that was involved in my case. But the one claim I did lose was when I filed, I also had named the prosecutor as a defendant for the misconduct that I referenced. And the judge dismissed my claim against the prosecutor. And in his footnote, he said that he felt constrained by the law to make that ruling, if that's what the law required, but that his ruling should not be interpreted to mean that the allegation wasn't serious or that I didn't have evidence of that. In fact, he went on to say that he encouraged me to file a grievance later. So when litigation was finished, I went back to my civil rights lawyers who had, really done a superb job. And I told them, listen, I want to take the judge up on his offer. I want to file a complaint. I mean, I don't want anyone to get away with anything. Even though these things are really inadequate, but it's what's there. I want to at least do what I can. And he told me, Jeff, it's a waste of time and money. Nothing ever happens. Don't bother to waste your time. But just think on a common sense level for a second. I mean, imagine for a second if you were wrongfully convicted, you were wrongfully imprisoned, and you spent a substantial amount of time in prison, and you later learned that the prosecutor knew a witness was lying and they didn't correct the testimony, or you learned that the prosecutor withheld evidence of innocence, or that the prosecutor threatened the witness. And then you were eventually exonerated, but you spent the time in prison. I mean, instinctively, wouldn't you feel like you're entitled to some justice, that you should be able to file a lawsuit and hold them accountable? But of course you would. That's instinctual, right? It just feels right. But if you tried it in real life, your case would get dismissed fairly quickly underneath the prosecutorial immunity document. So, I say that we should remove the immunity. There's no other professions, they don't have that. The pushback arguments are, well, we don't want there to be a chilling effect, and we want the prosecutors to have a free hand to prosecute cases and not worry about retaliatory litigation, and we want them prosecuting cases, not defending lawsuits. But my answers to those arguments are that, no other aspect of the justice system, they're not, the police, forensic scientists, they're not restrained from doing their job. There's no chilling effect. If they don't want to face litigation, it's kind of simple, actually. Don't break the rules. Don't run over constitutional rights. Don't withhold information. Don't engage in misconduct. You don't want to defend cases? Okay, don't commit a civil wrong. I mean, why is it that we have this one class of people that have to be above the law? And again, if you're an ethical prosecutor, you're playing it by the book. You have nothing to fear. It's just if you're doing something wrong, then you have something to fear. And you should have something to fear if you're not playing things by the rules. So moving past that, California really recently they passed a law. I'm not sure what class of felony it is, but they made withholding evidence a felony in California. So I think that criminalizing, again, we're talking about clear cut and intentional, not a gray area, not a mistake, nothing unclear, just intentional withholding. I think that just like somebody who commits a murder, right? If you're a defendant, right, and you commit a murder, yes, you face criminal charges, but the victim's family also would have the option to bring a wrongful death suit as well, hold you accountable on the civil end. So looking at applying that rationale, that logic to the situation, yeah, I think that if the case warrants it, there should be criminal charges that are looked at. Because if you think about it, a person who is a prosecutor who is withheld evidence of innocence and wrongfully convicted somebody, they've in effect pulled off a kidnapping under color of law. I mean, I can't look at it any other way. In terms of just trying to preserve the fairness of trials, right? I mean, we rely on trials in order to try to determine guilt, innocence. And when a prosecutor engages in misconduct in the course of a criminal trial, they upset the trial's truth-seeking aim. Once misconduct has happened, the lens from which everything else happens in the case, the evidence and the ebb and flow of the entire complexion of the case changes once misconduct has happened. So to me, the only way that somebody could have their right to a fair trial restored once misconduct has happened, there's one way and one way only. And that would be to give such a person, give them a new trial. There should be a per se reversal rule, meaning if there's misconduct that happens, there should be an automatic reversal. Let them get a new trial, let prosecution try to think he's guilty, okay, maybe you're right. Re-prosecute, have at it again. No misconduct this time, and not by the same person who committed the misconduct. But the way that things are now, the state of the law now, the court engages they call, a harmless error analysis, where they try to look back in hindsight and say, well, yeah, misconduct happened, but it doesn't matter because, you were going to lose anyway, you're going to be convicted anyway. It's harmless. We're complaining about it's harmless, it's harmless. Well, I don't feel like I need the legal education here in order to know that, well, obviously, if it was harmless, why would they bother to engage in it, right? Does anyone need a law degree or legalese to understand that part of it? If the misconduct was harmless, the prosecutor would not have bothered to engage in it because it would have been a waste of time. Of course, it's not harmless, and to look back and try to determine what would have happened, it's impossible, and that type of approach has the impact of just having somebody never having their right restored to a fair trial. And so when that happens, who knows whether or not, the verdict is accurate or if it's not. So those are my thoughts. Look, I really appreciate everybody coming out tonight, giving all of us attention. Thanks a lot for coming out, and we're going to do Q&A. Right now, we're going to close the speaking part of the program, and thanks for listening to all of us.
Thank you very much. Thanks to all the speakers. Does anybody have any questions to any of our speakers?
How do you get around, like after many years of all this stuff happening, and when you have the statutory limitations? How does that come in? How do you get around that? Because like to go after someone and then you find out there's been only 2 years of statutory limitation on that issue. So then,
statutory limitations on what? I'm not clear.
like to sue someone, it's like there's for something that has been like said against you.
Yeah, but is this related to wrongful conviction you're asking?
Yeah.
Well, when you're talking about a compensation case, like 1983 lawsuit in connection with wrongful conviction, the 3-year clock doesn't start running until the operations happen.
All right.
Dr. Sorochinski, I want to just recognize local high-powered defense lawyer Tony Castro, who ran Bronx homicide for 10 years as an ethical prosecutor.
Jeffrey, I don't know about high-powered, but...
I've seen you get some amazing results from plenty of people I've said to you, so I understand you have a great story to share.
Yes, thank you, Jeffrey, for giving me this opportunity and inviting me to hear this wonderful panel of experts on the topic. I do have a little bit of a background in criminal law. I was a Bronx prosecutor for 14 years, about 14 years. And I left in 2001 to run against Janine Perro for Westchester, DA. At the time, I was the deputy chief of homicides in the grand jury bureau in the Bronx. So, needless to say, I saw many, many, many cases. I made decisions on many, many cases. But Jeffrey had asked me to share one particular case of the many thousands of cases that I handled where someone could have ended up wrongfully convicted. So let me share with you just briefly the process in place at the Bronx DA's office as far as homicides are concerned. This case happened sometime in the mid-90s. I don't know if it was 94, 95, somewhere. I don't even remember the names, but I can tell you the facts. Okay? And basically, the process, the policy in the Bronx is that no homicide, there is no arrest on the homicide case without the DA's approval. That's safety valve number 1 at the Bronx and Bronx County. Now, is Bronx County DA's office perfect? Of course not. The system is not perfect. But I'd like to think that the Bronx DA's office over the years, especially when I was there, did the right thing for the most part. I think they did more so than many other DA's offices throughout the state. Why? Because we had DAs, and at that time we had Rob Johnson, who frowned upon any misconduct on the part of any assistant. And that's where it starts. Okay? It starts with the elected DA. Okay? Because if that elected DA feels strongly enough about any possible misconduct being conducted by one of his or her assistants, well, guess what? That assistant, who even thinks of committing a prosecutorial misconduct, will think twice. Oh, I'm sorry. Okay. Yeah, so anyway, so that's where it starts. Okay, it starts at the top. Okay? Because, again, if the elected official, and by the way, just so you know the makeup of an office like the Bronx DA's, you have one elected DA, and you have almost 500 assistant DAs. That's what you have. Just to give you an idea, broken down into different departments. So in 94, 95, I was the deputy chief in the grand jury, and also the deputy chief of homicides. This one homicide, which I believe happened in the 4-7 precinct, came to me, an arrest was made, so at some point, and I had gotten the approval of the DA's office at the outset to make the arrest, because that's step number one. Step number two, it came into the grand jury, where I was the supervisor, I was the deputy chief at the time. The case was given to me to oversee the indictment of this individual on the homicide. And the way it works in the Bronx, and I think mainly in the big offices, is we abide by what's called the CPL 180-80 day, meaning that you have to take action within 6 days of arrest. You either present the case to the grand jury, or the defendant gets released. Or, unless the defendant, of course, consents to an extension of the 6 days, because the DA may be investigating the case, some evidence that the defense has put forth. So, within the 6 business days, or the 6 days, I should say, 180-80 day, I was able to interview a number of witnesses that were brought to me by the detective team. And I still remember, it was a short Hispanic woman and a tall white guy. Don't remember their names, but I remember the team. And they came to me and provided me with the witnesses for me to present to the grand jury to indict this individual on a murder case that took place in the 4-7. I started to interview the witnesses, and as I interviewed the witnesses, something didn't seem to add up. Much of the way, very similar to what Professor Ben Gershman said when he was at the DA's office. You sort of get that gut feeling that something wasn't adding up. It just didn't make sense. And I expressed some reservation to the detectives, and I asked them if there were other witnesses, if there was more evidence that for me to consider. At some point, I asked to speak to the victim's family because I was concerned about the case, and I wanted to have the courtesy of speaking to the victim's family to share that. The family came in, and much to my surprise, they said, "Tony, we agree with you. I think you have the wrong guy." It's a true story. And I said, "What do you mean?" He says, "Well, there was so-and-so, this other witnesses we heard about, word on the street, that it may have been someone else." So I started, following those leads, all within the 6 days, all within the 180-80 time, okay? I started following the leads, And sure enough, by the 180 day, when I had to decide whether to indict this individual or have to release him on a murder charge, right? I had concluded at that point that we had the wrong man. But not only did we have the wrong man, I actually knew who the murderer was. In other words, so I felt very comfortable based on the investigation that I had conducted within those 6 days. I was very comfortable that I knew who the real murderer was. So I called the detectives in, this team that I described to you, but I'll never forget this. I told them, I said, listen, I think you have the wrong guy. And not only do I think we have the wrong guy, I believe you should be looking for so-and-so. Never forget it. The female detective looks at me, looks up at me and says, as far as the NYPD is concerned, this case is closed. Never forget it. Yep. And I said, really? I says, well, as far as I'm concerned, the defendant is released.
Yeah.
I went downstairs to Raymond's, and I told the judge, release him. Right? I said, we didn't dismiss the case yet, because I wanted to conduct further investigation, but I was fairly certain that this man is innocent. So I released him. Never happens. Never happens. Oh, I shouldn't say never happens. Rarely happens, and that's why we're here. Okay? But now the story gets better. As Jeff knows the story, that's why he asked me to tell him. About 2 weeks later, so the defendant is out, the case is still pending, but the defendant is out. About 2 weeks later, I get a call that an individual was arrested in Manhattan for a gun possession. And the circumstances of the arrest were such that he was in the back seat of a taxi in Manhattan. And I guess he fell asleep, but the driver thought something happened to his passenger. So the driver of the cab pulled up to the street corner and saw 2 officers and said, officers, I think something happened to my passenger. So the officers come around, back passenger door, and they open the door, and they tap the individual to see if he was okay. Well, it turns out he was okay because he woke up. When they tapped him, they felt a bulletproof vest on him. So the minute they felt the bulletproof vest, they took him out, they frisked him, and they recovered a gun. So he was prosecuted in Manhattan. He was charged, he was arrested, he was charged in Manhattan with a gun possession. New York ballistics, NYPD ballistics, runs the gun, and where do you think that gun came back to? the murderer of the 4-7. And guess who that individual was who got arrested for the gun possession? The same guy that I told the detectives, go and look for that guy. True story.
Other questions?
Just come up closer because we only have so much fire. Oh, no, because one goes
Okay.
into that. Yeah.
There's something I want to ask about a victim. Name is Frankie. We'll stay at that. He was approached at home by police officers and taken down to be questioned at the police department over a rape case. They had him there for several hours. He finally signed a confession that he did it, which I believe 100% he was coerced. After signing the confession, the police officer said, you can go home. Now, if someone signed something that said they did something, why would officers say you can go home? He stayed home for over 2 months. Then they came back later and he turned himself in. Now, the evidence that was collected while they were in court, the judge recommended that they get a medical report on the victims, so-called victims. And I want to say so-called victims, excuse me. They got the medical report, court order. When the report comes to the court, the prosecutor denied it and somehow kept the medical evidence from coming into court, which would have showed that nothing had happened to these girls. I want to know how can you get around something like that. The medical evidence was not allowed in court. There was also a medical examiner that came and testified for 3 days in favor of Frankie. He was asked by the court. They excused his testimony, told the jury that none of that's allowed because he was paid a fee by the court and it escalated over a certain amount. So the medical examiner's testimony was thrown out of court. The medical evidence from doctors, from universities, was not allowed in court. Until this day, Frankie is sitting up in Osborne. It's been 13 and a half years now.
Well, there's so much to this case. But the thing that I really want to get out there is, we are from Connecticut, and there is something called the multidisciplinary team in Connecticut. I don't know if you have that in New York or not, but that's where the prosecutor has a connection. He's on the board of the Children's Connection. He's on the board of the Children and Families. He's on the board of a police commissioner. He's on the board of the psychologist board. So he's everywhere. He wears all these hats. So, like, when something goes on, he's there. You know, so he stops you from getting anywhere. And I have proof of everything. He actually discredited our expert witness that was a neuropsychologist because the other side's psychologist wrote to him to show him how to discredit him. And then I find out that he was sitting on the board of the psychologist, and there was a misdemeanor that the psychologist had some kind of issue. So he knew about that a year before. He shouldn't have even been on our case. I mean, that alone shows that there was a conflict of interest. All this stuff is, you know, it just one thing after the other that shows the miscarriage of justice, but also I could go against this prosecutor with so much things, but he stands in the way of it because he's the power in Connecticut. And everyone in Frankie's case got a promotion. He was assistant, he's now, you know, the head honcho. You know.
I do want to add that medical examination is in this file.
Does anybody want to respond or comment?
Well, look, I mean, the key in trying to undo any wrongful conviction, the first thing is, you know, you have to get legal help. I mean, that's where it starts at. I mean, doing pro bono, or, you know, trying to get, you need to get a lawyer that can help you, that can review the record. The lawyer has to find, you know, the trick of doing a wrongful conviction is you have to, the burden of proof is shifted. Once you've been convicted, the burden's shifted, and now you have to try to prove you're innocent. So that means you've got to try to find directions and leads to go in. Then you need an investigator to actually run the leads down, and some of those have to break your way in order to then have that as the basis for a post-conviction motion.
I have a lot of evidence that has never been presented before.
There's been an investigation.
Okay, so All right, so look, what you should do is you should put together like a really tight letter and send it around. We can talk about that offline. I want to get some other questions as to the substance of it, okay? But I do empathize with you though, okay?
Hi. I wanted to ask, I read this really sad story, I think it was in the New York Times, about a young black kid who he was also wrongfully convicted and he ended up going to prison. And I forgot how he ended up getting out, I don't remember. I think he actually served his whole term or something about how they accused him of stealing like somebody's backpack. Yeah, it was that thing. Yeah. Right, oh, okay, it was dismissed. But he spent so much time in Rikers waiting for the case that he got really depressed and everything, so by the time he got out, he committed suicide. And I'm wondering, you know, I can't imagine how much emotional suffering you would go through, and for anybody. And I'm wondering, you know, when you're sitting there, you know, you do it, is there any kind of mental health, like do they have therapists, do they have counselors, support groups? Like how do you get through it emotionally until it's resolved?
Not nearly enough, that's the short answer.
Well, in terms of mental health assistance while you are still wrongfully imprisoned, I mean, just in terms of getting through being wrongfully imprisoned, the answer is they don't have anything for that. No, the prison officials assume, they work off the assumption that, you know, you're guilty unless and until the court tells them different. So they don't offer any services for you while you're there. Okay, at one point I did seek services just because you have to, it's not just a fight externally as against the DA's office or even to some extent the courts and even just trying to get, you know, a fair hearing on your claims, but you're simultaneously fighting a mental battle. So you have to fight to not give up, you're fighting feelings of hopelessness, helplessness at times, suicidal thoughts get in your mind. So at one point I did seek to avail myself of the limited mental health assistance I was there, but I was told, look, we have way too large a caseload and we're only dealing with people that are like psychotic and have delusions, so we have no time really for you.
Do you know if there's any efforts being made to change that?
No, there's no efforts being made at changing that. That's really, you're the first person I've ever taken a question from on the issue of assistance for mental health assistance for wrongfully convicted people while they're still wrongfully convicted and in prison. You're the first person I've ever heard even ask me that. So, you know, so no, there's no one working on that. Maybe you could get started with that, maybe, but it's a lot of work. But go ahead.
I just want to add to your question. My name is Zulay Velasquez, and I'm a wrongful conviction advocate, but I have a nonprofit called Absolutely Innocent, where we focus on some of the loopholes that are not served by other organizations, and one of those are therapy. So we started doing peer-to-peer and therapy for the families, and we are going to expand on that and build a coalition not only of just therapists and physicians, but also attorneys. So yes, and I'll give you my well, it's a work in progress.
Thank you.
Thank you. Bill, I work with you and Ben, Jeff, when it can happen to you. I just want a clarification. Hopefully we can tell the people. What is the actual cost of prosecutorial misconduct as it relates to the taxpayer having to pay the compensation for the wrongfully convicted? Do we have a number on that?
Well, I can tell you that the 11 cases that we looked at, they range from $7.5 million to $16 million. But there's three components to every wrongful conviction case. One is time that they spend in prison. Okay? So that's at a cost of, I believe it's
That's $65,000.
So you multiply that by 20 years. Okay? Then you've got the conviction settlement, which is paid up. And those costs range from $7.5 million to, in Dewey Bozelli's case, it was $16 million. $16 million in one case.
One case. Have you totaled it up totally?
Well, we totaled up these 11.
Those 11, can you give us that number?
120 million.
120 million. I know one thing that I asked for. I said, my civil lawyers asked me, what are you going to settle for? And I said, I'm going to settle for $1 more than Jeffrey Nesbitt got. So that's like 100 million. But no, $120 million is a high cost to pay. And were these prosecutors to abide by the rules, were there to be some sort of deterrence as by the commission that you want to create, then maybe the taxpayers won't have to pay that deficit, won't have to pay that budget. And then that money could be used for maybe getting books for schools, as you said, or maybe paving roads that need to be paved. So there is a cost to these prosecutors refusing, these lawmakers refusing to sign on to this bill. We're getting close. I think that we're going to get it, Bill, and I'm going to keep working with you, Jeff and Bennett, and thank you for your time.
I want to mention one thing in the anticipated budget for the commission is $3 million a year. Okay? Now that's what the Commission on Judicial Conduct costs. That's for 3 offices across the state revenue. And when the Commission on Judicial Conduct was formed, their budget was much higher. It was quadruple that. And the reason it's so low is because there's been less cases of judicial misconduct because the Commission on Judicial Conduct has been there. Okay? So that deterrent effect is real. It would be very difficult. You would have to be a very, very, very bad prosecutor, such as Mary Graves, to be removed by the governor. And only the governor has the power in the state constitution to prosecute. And in many, many cases, it would be a slap on the hand. But rest assured, it would not do it again. It's like getting an IRS line. You get outed by the IRS ones. Here's a lot more trouble. What you do the next time you file it. So, if you get audited by the commission or reported by a defense lawyer because you're a serial violator rating, and this defense lawyer, like in my case, always had flights. And in my case, the prosecutor, Christy Carlo, was a known serial violator. Okay? The public defender's office could not stand her because they knew when Christy had a trial, they were going to have to fight on the screen. I had high-powered attorney from Francis. Okay? And he wasn't going to court, so we got the siren, okay, which predicted the date and time.
All right, so we're running out of time. One last. We're supposed to.
Right now, I need the second one, so.
Give me the other one. Yeah, okay, just a couple people can live on Facebook.
Oh, that's great. So this is a question for Professor Gershwin. So, unfortunately, the more severe the crime, there tends to be a greater tendency to jump to conclusions on something, even though those are the cases where you should be the most careful. So do you have any advice for young prosecutors starting out to avoid jumping to conclusions on cases like that?
Nice question. We had a panel here last year involving 10 of our graduates, many of them I taught, who became prosecutors. And the one common theme that all of these young men and women who are now prosecutors noted was they couldn't believe the power they had. That was they became prosecutors. They were just fascinated. They were struck by how much power they had. And my sense is you've got to slow down. You've got to look at the case carefully. And you've got to use your own good judgment, because ultimately it does come down to judgment. You know, when I teach students, brains isn't what it takes to become a good lawyer, whether you're a prosecutor or a defendant. It takes hard work, preparation, and judgment. And young people have to use good judgment. And you have to struggle with these cases. Too many prosecutors just, they look at the file quickly and then they'll decide whether it's real. And that's something that I think many studies have shown, that too many prosecutors just move too quickly. You know, I just think that it's such a wonderful job to be a prosecutor. Those are the most wonderful years of my life. But, you know, it's a question of integrity. Integrity means, you have integrity doing the right thing when nobody's looking. That's what integrity means, doing the right thing. And prosecutors have to think about that. What's the right thing to do? It's a moral question. Yes, it's an economic question. That taxpayers are being foot the bill of millions and millions of dollars. But ultimately, it's a moral question. This commission is a moral issue in our society. And you know, whatever happens, you know, it's going to be up to the public and the governor who's being questioned. So I just think that young people who are going to be prosecutors, they have to think about what's the right thing to do. I've got so much power, I can use that power wisely, or I can abuse that power.
Can I say something? This up-and-coming prosecutor. You know, my defense attorney, when he lawyered me up, he told me what was going to happen. This was the day after the sheriff's investigators investigated. And he called me in, and the sheriff called me back the next morning and said, left me a voice message because I refused to admit during this interrogation that I raped this young girl. And he called me and left me a voice message, and he said, we'd like to just sit down and have coffee and just wrap this thing up. So I called my attorney back, who I thought it was earlier, and John said, Bill, I got to get you in here, I got to lawyer you up. I had no idea what lawyer you up. And we sat there and with my wife, and he said, Bill, I told him about the hour and a half interrogation. He said, here's what's going to happen. You're going to be arrested, you're going to be indicted, and I'm going to have to fight like hell to keep you out of prison for the next 2 years. And I said, wait, how do you know that? And he said, because that's the way the system works. When I started 20 years ago, it was pretty much a clean system. And it was a vertical system. It was an adversarial system of justice. It's not an adversarial system in many prosecutor's offices. It's the sheriff's department, the police department, prosecutor, not challenging one another, working in concert. Squirrel was interviewed. Okay. And that system of checks and balances, maybe not but what I've seen, as I've looked at the cases I've heard of, the prosecutors, agents in their office, the investigators, did not do due diligence, did not double check on the sheriff's department or on the. So what good does it do? They have a private investigator, I understand. you're not going to use them. Okay? Gary Mason is great. But in my case, the girl claimed that I locked the shed door in Rochester behind her and threw her out the door. I ran into a friend of mine who went and went to Superman 4 months after my arrest. She said, Bill, she said, I've been meaning to call you. I grew up in Rochester. You can't lock the shed doors behind you. Because they made a new rule because little kids were locking themselves in the shed and parents couldn't find them. Every one of those locks on that shed. Sheriff's never even bothered to do this and check the lock. I tried to investigate it.
I just want to add one thing. Bill makes a good point. One of the problems that reinforces prosecutorial malpractice is the close bond, the close relationship between prosecutors and police. And that's a serious problem. That's one of the reasons why people are calling for special prosecutors when police kill somebody. If you're interested, look closely at Rensselaer County right now, because the prosecutor there is named Joel Appalach. And if you want to see the relationship between prosecutors and police, keep an eye on this case, because I have a feeling this prosecutor could get indicted. He's being investigated right now by the Schneider office. There was a police killing. This prosecutor should have, under the governor's executive order, allowed a special prosecutor, Schneider, to be appointed. This overload rushed the case into a grand jury. He gave the police officer immunity, and he got the grand jury very quickly to vote no indictment against the cop for killing this individual. And I think it's pretty clear there were witnesses who said the cop was unjustified. He didn't call those witnesses. And he has all sorts of connections with the police. So this is a case where he stands out in terms of this tandem, this tag team, prosecutor and police. So that's an issue that I think is very serious. And it does confound the ability of the prosecutor to engage in this kind of
All right, so we have one last final comment.
That's all. We got absolutely got to meet our police.
Actually, I don't have a question. I just wanted to shed some light on what the young lady said in the back, in asking about, the conditions for the wrongfully convicted person in the prison. I just want to shed light on that it not only affects the wrongfully convicted person in prison, but it also affects the family. There's lives that are left behind. There's mothers and there's wives and there's children, and we're all affected by this wrongful conviction. Okay, families are destroyed because of wrongful conviction. It pulls a husband, a father from his family, and he no longer has that contact, that bond between his children and his parents and his wife. So it just totally destroys not just the wrongfully convicted person, but the family as well. And we, myself included, I think about it all the time, that we need to start having forums like this where we address those issues. What do we do to help the families, the children that are left behind without parents to care for them?
Thank you. Thank you very much. And I think that's actually a powerful way to close our session today. Thank you again for coming. Thank you to our speakers, and thank you to the Jeffrey Bastuk Foundation for sponsoring. Thank you to Pace University for hosting us once again, and have a good night.